Sure. I'm Steve Shapiro. I'm the National Legal Director of the ACLU. I think so. And then that in turn makes it even more frustrating when the court strikes down important legislation that's been adopted by the political branches to try to remedy the ongoing vestiges of discrimination, as the court did last year with the preclearance requirements under the Voting Rights Act in Shelby County. I think that decision was wrong, and I think it's already had a serious impact. We have seen a small avalanche of state laws that I think never would have been pre-cleared by the Justice Department under the old Voting Rights Act, and now have to be litigated state by state by state in a way that is very costly, very time-consuming, and very difficult. Yeah, I think those cases now require very extensive factual records to try to persuade the court that the discrimination we are fighting is not simply a matter of history, but a matter of current reality. And we recently obtained a decision from a federal district court in Wisconsin striking down that state's voter ID law. That case is on its way to the Seventh Circuit. But the decision by the judge in that case was based on a voluminous factual record, extensive and quite expensive expert witness studies, and he attached a series of appendices to his written judicial opinion in which he went through all of the statistical evidence that demonstrated, I think irrefutably, that these voter ID laws did almost nothing to combat a problem of fraud, big voter fraud, because that problem didn't exist, but they had a very dramatic impact on the ability of racial minorities to vote in the state of Wisconsin. So I think a lot of this now is a real slog to make the case. And when you make the case in court, you're simultaneously hoping that you make the case in the court of public opinion as well, because one of the things that litigation does is litigation is an opportunity to tell a story. And if you tell your story well, then hopefully it has a wider audience. Yeah, all of our advocacy activities now are very consciously and carefully integrated. And so the records that we compile in the course of litigation are then used in front of legislatures to either discourage them from doing bad things or encourage them to do good things. And the stories that we develop in the course of litigation, we try through our communications department to get out to a wider audience, either through social media or through our own website or through talking to journalists who we know are interested in these issues. And so we almost never approach things anymore purely as litigation matters. We think of, there's a goal we have in mind, and we think of how do we best achieve that using all of these parts of our toolbox. Well, I don't think that, when you get in court, the process doesn't look much. I mean, maybe we think more about facts now than perhaps we once did. When I first started the ACLU, a lot of our work, frankly, involved what we call paper cases. They were summary judgment motions. We were fighting about the constitutionality of a statute. There wasn't much dispute about facts. Now we're much more heavily engaged in facts than we once were. But when we get in the courtroom and we're presenting witnesses, we're writing briefs, we're arguing cases. We're lawyers, and we do what lawyers do. And I don't think that has that has significantly changed. But when we think about what our priorities are going to be as an institution, and we go through that process continuously, we think about what our priorities are as an institution. One of the things we think about, not the only thing we think about, but one of the things we think about is what are the areas where we think we can have the most impact and the greatest likelihood of success. And when we are trying to evaluate our impact and our likelihood of success, we don't think only in terms of court victories. We think of the various ways in which we might succeed, and in the ways in which a success, in the legislative arena can reinforce a success in the courtroom and vice versa. Well, the way the organization handles it is that the lawyers are, by and large, specialists, subject matter specialists. And so the legal department of the National ACLU, the department that I direct, is divided into 14 projects that span the scope of work that the ACLU does, from women's rights and reproductive freedom to immigrants' rights to prisoners' rights to speech privacy and technology to voting rights to capital punishment. There are 14 different areas, and the lawyers in those areas focus almost exclusively on their subjects and are expected to become, and I think do become, national experts in those fields. They're deeply immersed in it on a day-to-day basis. I, because of my responsibilities as the director of the program, and by dint of just my interest and personality, I'm a generalist, and so it's probably fair to say that there are very few areas that I know with the depth that the specialists know, but I do have an understanding of the breadth of the issues that the ACLU covers, and to me that's always been interesting. And one of the things, one of the many things that is both fascinating and challenging about working in an organization like the ACLU is because we are not a single issue organization. There are moments when we have to confront cases in which there are two sides are both making a claim of rights, and we have to try to figure out some principled way to resolve that clash, and that's never simple for us. Sure. Well, the example we used to give in the old days, but it's largely an historic example, was free press, fair trial. So you have a suppressed confession that is leaked to the newspaper, and the newspaper wants to publish the confession, and the defense lawyer comes in and says, my client can't get a fair trial if the suppressed confession is published, and we care about the rights of the press, and we're opposed to prior restraints, and we care about due process and fair trial rights. And so how do you figure that out, right? But the law has more or less figured that problem out, I think. And so now the current example, and there's a case in the Supreme Court this term, is abortion clinic picketing. Because we are very deeply committed to reproductive choice and the right of women not only to have an abortion, but be able to access abortion, to be able to walk in and out of clinics without being harassed or threatened or intimidated. But we also believe, notwithstanding our support for reproductive rights, that people have a right to have a different view and to express that view on the public streets, including outside clinics. And how do you balance that when you have either a claim that the police are doing too little to protect the rights of the women going in and out of the clinic, or doing too much to infringe on the rights of the protesters? And there's a particular case from Massachusetts before the Supreme Court this term involving Massachusetts' solution to that problem, which was to create a 35-foot buffer zone outside of clinics in the state. And those are hard cases for us, and we really struggle with them. No, I don't think it's ad hoc, although it's a conversation that we wind up repeating a lot, and because you're trying in those cases, I think, to truly balance competing rights. no two cases are exactly the same, because in one case the restrictions on protests can be more onerous than in another case, and or vice versa, and that may lead you to a different balance, right, and a different bottom line. But there is certainly an extensive process of discussion that takes place, and it takes place within the national office, and it involves typically the people who work on reproductive rights and the people who work on free speech rights, and it involves not only the lawyers at the national office but the state affiliate, whose law is now been called into question because they may have lobbied for or against that law as it was going through the state legislature. And we all get together, and through a series of discussions, we try to figure it out. And then part of my job, certainly when we're taking positions in the U.S. Supreme Court, is to try to ensure that our positions are consistent and defensively consistent across cases, and that we're not saying something in this case that contradicts something that we said last year or that we may want to say next year. And that part of the exercise that we often go through at the ACLU, it's a little bit of an exercise, but I think it's a useful one, especially in free speech cases, is we say, let's assume the politics were reversed, and that the protesters were articulating a message that was 180 degrees from the message they are in fact articulating. What would our position be? Because we really are, in that sense, a nonpartisan organization that tries to operate on the basis of neutral principles, and whatever rule we come up with has to be valid not only for speech we may institutionally support, but for speech we might institutionally oppose. And that's, it's not simple. We may not always get it right, but it's a process I think we take very, very seriously. I think both the premise and the conclusion of that question are wrong, in fact, because we are in many ways deeply connected to the constituencies that we represent. We have a very deep connection to the reproductive rights community. We have a very deep connections to the gay and lesbian community. We have deep connections to the civil rights community. The fact that we have affiliates in every state gives us, almost uniquely among the major civil rights organizations in the country, a presence on the ground everywhere. The NAACP has that, for example, but many organizations do not. So it's not simply a question of lawyers or lobbyists sitting in New York or Washington and trying to dictate to the states. I mean, most of this for us bubbles from the ground up. So I think we are deeply, in fact, connected to the communities that we represent. And then, I like to think that we have, over the 94 years that we have been in this business, developed a reputation, certainly among judges, and I hope among the justices of the Supreme Court, as an organization that is principled, and B, is good. And so I think when people read our briefs, they may agree or disagree, but I don't think that most judges come to them thinking we have a particular axe to grind. I think they come to it saying we're involved in a sincere effort to interpret the Constitution according to a set of principles, for sure, that we believe in, but in a truly nonpartisan way. I mean, we have represented clients on the far left and been pilloried by the right for doing so, and we represented clients on the far right and been pilloried by the left for doing so, and I think that has served the ACLU well.